There is a lot going on, but the DA in Georgia has been on a roll, a 4-0 record in converting defendants into convicts in that Trump RICO case. Well, today we got some dramatic arguments there because Trump's lawyers were actually appearing in this packed courtroom for the first time. And they are trying to make their defense as they watch others turn and flip on Trump. They argue that because he was talking and using free speech, in their view, when he claimed there was voter fraud and tried to overturn the election, that somehow he should not be subject to the RICO laws of the state of Georgia. So what you're seeing here is new. These are Trump's lawyers in the Georgia RICO courtroom for the first time. And they want the whole thing thrown out. Indeed, they argue, and they have every right to make their defenses, that this is now not a RICO case, but more like, quote, election interference.
Can you imagine the notion of the Republican nominee for president not being able to campaign for the presidency because he is in some form or fashion in a courtroom defending himself? That would be the most effective election interference in the United States.
That's the argument. Trump's lawyer basically saying that what Donald Trump has argued, that this is somehow a persecution or a political process. That should mean he's not subject to election laws. In this case, the election racketeering conspiracy that he's accused of, that he shouldn't even have to defend himself in court. The prosecution pushed back.
This trial does not constitute election interference. Let's be clear. This is not election interference. This is moving forward with the business of Fulton County. I don't think that it in any way impedes defendant Trump's ability to campaign or do whatever he needs to do in order to seek office.
Likewise, the prosecution dealt with those free speech defenses.
You know, we heard from the other side these grand statements about this is a prosecution of political speech, this is a prosecution of expression, this is a prosecution of association, petition, etc. That is not true. And the indictment tells you so. This is a prosecution for violating the Georgia RICO Act, individuals conspiring to participate in a pattern of racketeering activity while associated with a criminal enterprise. It's a prosecution for solicitation of violation of oath of office, false statements and writings, impersonating public officers, and the list goes on and on.
That's what it sounds like, but what does it mean? Well, we turn to former federal prosecutor John Flannery, who's with me here in Washington. Good to see you, sir.
Good to see you.
At times it sounds dry, and that's what these kind of pretrial hearings can be.
Right.
And yet they're talking about very big stuff, including whether or not there will be a RICO case against Trump. What stood out to you about what we just heard?
Well, what stood out is that if you don't have a standard by which to compare what they're saying, then you don't understand what they're doing to us, which is there is few of us, if it were stated this way, even by the prosecution, that, I'm sorry, but, you know, inciting a riot, that's not petitioning your government.
Yeah.
Interfering with a government proceeding, that's not. So it's the thing about it's speech plus, and it's speech plus bad acts. And it's not just saying, oh, I think we're doing something wrong here. And then the irony that the prosecution maybe feels constrained that they can't say is to say, he has some nerve coming into this courtroom and talking about us interfering in an election when he interfered in an election and his biggest campaign promise is his lie that they stole the election.
Well, you know what they call that in the Deep South? They call that chutzpah.
Chutzpah, yes,
yeah,
I
chutzpah,
know.
That's what it's called.
But I want to build often in Manhattan than I hear it in the Deep South.
I want to build on that because we also excerpted another part of this I want to play right now for the first time today.
Sure.
This all went down today where, as you refer to it, the Trump lawyers say, oh, it's unprecedented. And guess what? It is true that some of this is unprecedented. The question is, which way does that cut? Here was the prosecutor punching back on that point.
Okay.
We heard from the other side that this is the first time a prosecution of this type has been brought, that it's unprecedented. And that may be true. But this is the first time someone a criminal enterprise has gotten together and tried to overturn the results of an election. So I don't think that's a particularly persuasive argument.
What is the prosecutor trying to get the judge to see there? Because the judge is supposed to be fair, not pick sides. The judge hears, oh, this is really unprecedented. True. And then the prosecutor is trying to do what?
Well, I think he shaves points. In other words, that was strong. That was stronger than the earlier clip that we saw. But the strength that he's missing is to say, It's unprecedented because there has been no one in the history of America that would do such crimes against the government, betray their oath of office, and think that an autocracy should replace a democracy. I think you can say those things. And also, since Trump and his minions are abusing the system, I think that you could say in that context that this is unprecedented, and therefore we have a burden to deal with it. And we have to deal with it in the courtroom and out of it, because these frivolous arguments they make today, they're not for you, Your Honor. They're for the team outside. This is one campaign. They're prepared to accept a conviction. I think they should say things like that. It's truth. They're prepared to accept a conviction because this is part of their campaign, to make you the enemy of the Trump campaign and everybody else who's on the court or a witness or a clerk to a judge in New York.
The other thing here is the calendar that hangs over all of this.
Yes.
We're talking going into the holidays.
Right.
Mid-January, you have the presidential primaries.
Right.
We have the prospect of a candidate here who could be convicted and run. He also could ultimately beat the cases. We don't prejudge that.
Yes.
I thought that the Trump lawyers made a valid legal point in saying that if Donald Trump, whatever happens, were to become president again, which is possible, as you know, John, then this state case, unlike perhaps some other ones, probably would have to sit in the back because we do have a supremacy clause in the Constitution. I don't know if you have a roundabout way to punch back, but this is Mr. Sato, the Trump lawyer, and he basically says, look, we don't live in a country where 50 states can constantly try or jail the sitting president were he to become that again. Take a listen.
Okay.
If your client does win election in 2024, could he even be tried in 2025?
The answer to that is, I believe that under the supremacy clause and his duties as President of the United States, this trial would not take place at all until after he left his term of office.
He put it, I see you're gearing up. He put it precisely. He didn't say no trial ever.
Right.
He said what we were told when the last time this came up when Donald Trump was president, which is a state case would have to wait till he leaves office, no?
No. And I know you're just stating their position. It's not something you necessarily believe, because I can't believe that you would believe that.
Because?
I'm sorry, I'm just teasing you.
No,
because,
I know, but...
Because the reason is this. You may remember Vice President Agnew. He was prosecuted while he was the vice president. He entered a plea of guilty and resigned from office.
I hate to lawyer you, but in a federal case.
Well, but the point is the same. The same in this sense. He was prosecuted while in office.